Jasmine, you're not able to see me, are you? I can't see myself.
Hello, can anyone hear me?
Yes, we could hear you. All right, good morning, everyone. This is Anita Earls. I am thrilled to welcome you to the second meeting of the North Carolina Task Force for Racial Equity and Criminal Justice. Thank you all for being here this morning. I know with my esteemed co-chair, Attorney General Josh Stein, we are excited for this morning's meeting. We have a lot planned, and I wish that we could introduce everyone so everyone knows everyone who's here, but we just don't have the time for that. I do want to take 1 minute to make you all aware of people who were not with us last time, who you need to know. And so I'm going to introduce the task force members who were not present last time, a brief introduction of some of the guests who will be participating in this meeting, and then some of the working group staff that weren't on last time. So when I introduce you, if you could, if you have your video going, and I hope all of you will use, for the time being, use the grid view so you can see everyone. Either unmute yourself and say hi real quick, or wave your hand so people know who you are. Although fortunately we do have the names ideally under your picture if you have video up. But at any rate, we have 3 task force members who were unable to join us the first time, who are here this time. So we have District Court Judge Brooke Locklear Clark. Judge Clark, can you give us a shout? She may be having connection issues, but I see that I'm getting this message. She's trying to connect to audio, but I'm assuming she can hear us and she's here with us. We also have a Superior Court Judge Alan Thornburg. Judge Thornburg, can you wave? Hello. Say hello.
Hello.
Awesome. Thank you so much. And then we have Chief John Letney. Can you say hello?
Good morning, everyone. Great to be with you.
Awesome. We have guests with us who will be participating in the meeting. First, Professor Cami Chavis, who is Professor of Law and Director of the Criminal Justice Program at Wake Forest University School of Law. Professor Chavis.
Hello, how are you?
Great. And we have Professor Jessica Smith, who is Director of the UNC School of Government's Criminal Justice Innovation Lab. Professor Smith.
Morning.
Hi. And we have facilitators who will be guiding the discussion part of our meeting from the National Conference for Community and Justice of the Piedmont Triad, NCCJ. And that team with us today includes Karen Dyer. Karen.
Good morning, everyone.
Thank you. We have Ivan Canada.
Good morning.
And we have Michael Robinson.
Morning, folks. Grateful to be with you this morning.
Awesome. And then working group staff include Leslie Cooley-Dismukes from the DOJ Criminal Bureau Chief.
Good morning, Your Honor. Good morning, everyone.
Hi. And we have Emily Mehta, who is a research and policy associate at the Administrative Office of the Courts, joining the staff team. Emily. Okay, I saw her name. I know she's on. I didn't warn people that I was going to ask them to say hello, so fair enough there. I want to say just a word about our meetings. We are committed to transparency in our work. So all of our meeting materials
Anita has frozen for me. This is Josh. Okay, Anita, you froze for a minute. If you can repeat what you just said.
Oh, I'm so sorry. I probably am having internet connection issues.
We heard you talk about the importance of transparency.
Thank you, thank you. And I was letting people know that the meeting materials will be posted in advance of every task force meeting at the website ncdoj.gov/TREC. And as well on the governor's task force website. We'll also be periodically updating that page with any emails that are sent to the entire task force, so the public has access to those, as well as any feedback that we receive from the public in the public comment form. So it's just important that all of you know that materials sent to the entire task force are public records and they'll be shared publicly. And the other exciting side of transparency and public involvement is that we are hosting our first public comment session on Tuesday, July 28th. This one will be from 10 a.m. to 12 p.m. We will have others that are in the evening, but next Tuesday morning, 10 a.m. To sign up to speak, members of the public can visit the task force website that's hosted by the governor's office. After you sign up, you'll get a Zoom link to log on and participate. You can sign up in increments of time, so you don't have to be available for the entire 2 hours in order to have your 2 minutes to speak to the task force. And if you want to watch the public, if you don't want to speak, but you want to watch the public hearing, there will be, you can visit the Attorney General's YouTube page and there'll be a way to view it that way. So we hope that all of you here on the task force, all of you in this meeting will share the information about this public hearing. I happened to look last night and we have maybe 5 or 6 people signed up. So there's plenty of space to sign up and comment. And I think this is really a crucial time to participate through a public hearing because you can really help shape the work of the task force. And we will have additional public comment sessions on September 3rd and 8th. And as I said, at least one of those, and probably September 3rd will be in the evening. So there'll be opportunities for people to participate. For those of you who are watching the YouTube stream, the links that I just rushed through will be available in the description at the YouTube stream. quick data team update. The materials we sent earlier this week are now posted on our website, which outlines who is participating in the data consultation team. And we're just really grateful that we have that resource to help us. So we are now going to vote on the minutes. And before we vote, I just want to share the basics about voting. We have a slide that reminds us what's actually in the executive order about how we should proceed. So the executive order itself specifies that we can make policy recommendations at any time by a majority vote of present task force members, and that a simple majority of task force members constitutes a quorum. So the next slide makes explicit what our policy is regarding attending and voting. So if a task force member is not able to attend a task force meeting or work group meeting, we certainly welcome designating someone who can attend on their behalf, who can participate, but the designee would not be counted as part of the quorum and wouldn't actually vote on recommendations. But we just wanted to make that absolutely clear. And so in your packet materials, we sent minutes from the first meeting, and I think we can share the screen just to show that document. But at this point, I would ask if anyone had any edits or changes they wanted to make to the minutes before we consider them. So you can unmute yourself and give us if you had any changes or edits you wanted us to make. Okay, I'm not hearing anyone stepping forward. The other thing I should say about voting is we are working with the technology and we're trying out different avenues. Today, we're going to try a poll. We may vote differently or use different processes in the future, depending on what works best. Ideally, we do a voice vote. That obviously is not, at least so far, we haven't figured out how to make that work smoothly on Zoom. So right now, at this point, Ellen is going to send out a poll and you can vote to approve or not approve the minutes that we circulated. So I'll give you just a second to vote.
Doesn't appear the radio buttons are working.
Yeah, I see that. I see the message that says hosts and panelists can't vote, which I think all of us are one or the other.
That is not by design. That is an error. My apologies. For later in the session, I will fix this.
Okay, so with everyone's permission, we will defer the voting until we get it set up the right way. I do apologize, but we're with us here. We'll get there. So that will bring us to me handing off to my co-chair, Attorney General Stein, to talk about the working groups.
Thank you, Justice Earls. I apologize for the lack of video. My computer broke this weekend and I'm using my daughter's computer and I don't know how to use it. So here I am. You have my voice, if not my face, which probably is to everyone's advantage. So want to talk about the work groups. And for the public who don't know that between the last time we met 2 weeks ago and today, we conducted 2 surveys. I wanted to explain that we sent a first survey to everyone where we asked everyone to place the executive orders areas of concentration, the issue topics, into specific working groups. And we also asked how many of the working groups we should have from a operational perspective. The results were very clear from everyone's first survey response that we wanted 4 working groups. And in the second group, we put forward 2 options of how to organize these 4 working groups. And there was a clear preference for the configuration that is on the screen right now. And so the 4 working groups are Group 1, Law Enforcement Management, Group 2, Policing Policy and Practices, Group 3, Court-Based Interventions to End Discriminatory Criminalization, and Group 4, Advancing Racial Equity in Trials and Post-Conviction. And just how I think about these issues, which is not, is just how I conceptualize them. The first group is about bringing people into policing and how we train them and the culture and ways that they operate, how we make it more professional. And you can see that in each work group, there are a series of issues. And Group 2, it's how do police do their jobs? How do they use force, investigate, community policing, choose to arrest or use some alternative instead. So Group 2 is policing. Then Group 3 and 4 have to do with the courts. Group 3 is kind of at the very early stages when a person has been arrested and is just engaging the criminal justice system and how the courts operate generally. And then Group 4 is the trials, the assessments of fine and fees, sentencing, and collateral consequences to convictions. You'll see that some of these topics are in regular print, some are in italics. The regular print are all ones that were explicitly identified in the executive order. So we have to address those. The italics are in response to ideas that you all put forward in the survey of other topics that are worthy of consideration by the working groups. And what I want to say is that just because this is not an exhaustive list, to the extent in your deliberations, in your working groups, you come up with other ideas that we should consider, we can do that. We are not limited. The executive order is explicit that we are not limited to a certain set of issues. So just know that when you all are debating it, if there's a worthy policy idea, share it, and we can consider it as a working group first and then a task force second. Before we do the next slides, I do want to talk about the assignments, because we also asked in the second survey, in addition to which configuration you preferred, where you would like to serve. And our first objective clearly was to accommodate people's preferences. And we tried to the extent possible to give everyone the preferred selection, but everyone I'm sure understands that we had to do a little rejiggering because we had to ensure that there was some balance among the groups in terms of the number of people. And so a few of you, we've asked for you to move to another group to ensure that we have a sufficient number of people in each group. So when you see your assignment, which we'll go through in a minute, if you have issues, just please let us know afterwards. I don't think it's worthy of taking up time today, but if you really don't want to do where we've asked you to serve, just let Anita or me or one of the co-leads know, and we'll see if we can accommodate your request. But of course, we hope everyone is willing and eager to serve in the group where they've been assigned. I also want to note that a few of you have offered to serve as chairs of these working groups. And I very much want to thank everybody who offered to serve in that capacity. We know it's a bit more work, and your willingness was really much appreciated. So now we'll go to the next slide and look at each work group separately to identify the chair and the membership. So on this first working group, I want to thank Mayor Colvin, who will be chairing. And as you can see, we have Representative Galliard, Chief Davis, and Sheriff Ingram on this task force, or this work group, excuse me. Group 2, Secretary Hooks is chairing this one. This one was far and away the most popular, and it makes sense because this is the core of what the public, we've all been wrestling with. And you can see all the other members of this working group and we very much look forward to seeing the results of y'all's deliberation and all benefiting from your hard work. Group three. Group three, we have Representative Moret as the chair, and you can see the other members of court-based interventions to end discriminatory criminalization. And group four, Mr. Attorney Hill is going to chair group four, and you can see the other members. So thank you all for that. One thing that we haven't done is finalize who will be our points of contact with the various organizations laid out in the executive order that we are to consult with. And that is something we will do in short order. We almost got that work done, but the calendar sped up on us and we didn't quite finish it. So stay tuned for being asked to be a point of contact with organizations. And really it's just a liaison to ensure that we get their input into our deliberations. So that is it on the working group. Anita, back to you.
Right, thank you. And we will make those assignments available to you, so you didn't have to take notes while we were flashing that by you. The next, I'm going to hand it over to Professors Chavis and Smith, who are going to lead us through really the next hour and a half. We'll have a break in the middle, but lead us through a discussion of the criminal justice system writ large, and really kind of set the stage for the work, all the work that we do going forward. So I will turn it over to you, Professor Smith.
Thank you. Ellen, I think, is going to pull up a PowerPoint slide. Talk amongst yourselves for a moment. There we go. Great. Thanks for having me this morning. I'm Jessie Smith from the UNC School of Government. I have been asked to do two things in this session this morning. First, to present an abbreviated systems map of the criminal justice system, highlighting key decision-making and data points that may inform your work. And second, to explore the bigger picture, because of course the criminal justice system does not exist in isolation. It exists within a larger context. So we will be exploring factors that influence who enters and who re-enters the justice system, things like what we criminalize, the availability of behavioral health treatment and the like. And we'll also explore factors that influence how actors within the system behave. Police officers, judges, district attorneys. We'll talk about things like the legal framework and accountability and the availability of data. So keep those things in mind, because when we get there, I'm going to be turning to you for your feedback. But my goal with all of this is to help you develop a framework for identifying and prioritizing your work as you break into work groups and get down to it. So let's get started. Feel free to interrupt at any time if you have questions. There is a chat feature in Zoom, and probably the easiest way, given the number of people and the fact that I can't see all your faces while the PowerPoint screen is up, is if you have questions, put them in the chat and I'll keep an eye on it, and hopefully someone else will let me know if there's an issue. So let's start with this highly simplified map of the justice system. This is not meant to be all encompassing. It doesn't include, for example, the appellate division. Sorry, Justice Earls. But the reason for this is simple. It's that it's designed to focus on the steps that you think may be most important to your work. And already I saw from the slides that were just shown by Attorney General Stein that we may have to add another step in here, which is the juvenile justice system as a feeder. But let's start at the beginning with the sort of first switch that turns on the formal criminal justice process, starting here with the light blue arrow. We'll talk in a moment about everything and re-enter. This is just a segment about the formal system. And the initial contact for how people enter the system can come from individuals. People like Sue, who calls 911 when she comes home and finds a homeless person sleeping on her porch. Or it could be from Greg, who calls 911 when he hears gunshots next door. That initial contact can also come from businesses like the Supercenter, when the loss prevention manager has detained someone for shoplifting. Now, individuals and businesses have two choices for initiating contact with the system. They can contact the police, typically through the 911 system, or they can go directly to the magistrate for something called a citizen's warrant. We'll talk about that in a minute. The other actor at the front end of the system is law enforcement. When law enforcement observes a crime or when responding to a call for service from Sue or from the Supercenter. Now, officers have a lot of discretion about how to handle that initial interaction. In almost all cases, they have discretion to decline to charge. They also have discretion to engage the person in pre-charge diversion, but that only works if the officer works in a community where there are programs and services in place for pre-charge diversion. If an officer decides to charge a crime, they have two choices. They can issue a citation or they can make a warrantless arrest. If they charge by a citation, the person gets a piece of paper that says, show up in court later and answer your charges. If they arrest the person, they're taken before a magistrate. Again, we'll get there in a minute. The golden key on the flow chart is meant to represent all the opportunities that someone has to exit the system. And here, when there's initial contact, but there's a decision not to charge or for pre-charge diversion. Before we go any further, I want to talk a little bit about how many and what kinds of charges make up our criminal justice system. At my lab, we looked at this issue, and I'm going to present some key data points for you. In 2019, North Carolina initiated about 1.6 million misdemeanor charges and about 343 felony charges. So about 1.9 million charges total. Now, most of those charges, in fact, the vast majority of those charges were for nonviolent offenses. We crunched the numbers on this. Here are some of the things we found. Of the 1.6 million misdemeanor charges, only 6.66% of them were for violent offenses. Of the felony charges, only 16.4% of them were for violent charges. Now, when we released this analysis, a lot of people contacted me. They were surprised. The fact is, we were surprised. I mean, we knew the system was mostly misdemeanors. We knew it was mostly nonviolent, but we didn't know the extent of the numbers. Here's another data point for your consideration. Of those 1.6 million misdemeanors that, again, are the bulk of the system, about 1 million of them are for non-DWI related traffic offenses. What offenses? We looked at that too. Here is a list of the most commonly charged non-DWI misdemeanor traffic offenses. Again, these are the offenses that make up about half of the system. And you can see here the chart, we listed them by most commonly charged at the top, and you can see there are 4 charges that make up a lot of those numbers. Speeding, expired registration, driving while license revoked, non-revocation, and no operator's license. We also took a look at other nonviolent misdemeanor offenses, and here's what we found there. Of the most common non-motor vehicle, nonviolent offenses, here's what they are. Misdemeanor larceny tops the charts, but look at the next 3 offenses. They're all drug-related misdemeanor charges. A final note about the charges. Those 343,000 felony charges, about 1/3 of them are for drug offenses. Why am I mentioning this? I'm mentioning these kind of facts and data points because they might ground some of your choices as you break into your work groups and consider your efforts. We just looked at the misdemeanor numbers and we're seeing the felony numbers. If you decide that you want to focus on dealing with certain behavioral issues outside of the criminal justice system, you can see, just as an example, that issues like substance use are a big driver of the business of the criminal justice system. Now, I talked earlier about officers having a lot of discretion on how to deal with that initial interaction. We don't have statewide data on how often they decline to charge or how often they use diversion. But my lab looked at the issue of discretion on whether to issue a citation or arrest. And we found that in the vast majority of misdemeanor cases, officers charged by citation. Here are the numbers. In 2018, officers charged about 88% of highest charge misdemeanor cases by citation. That's the statewide rate. There is variability at the county level. In Transylvania County, for example, it was only about 71% of misdemeanor cases got charged by citation as opposed to an arrest and to a magistrate for charging. At the high end in Anson County, it's over 97% of misdemeanor cases. So there is some variability and the numbers are big. It's about 945,000 charges by citation in 2018. So you can see with those kind of numbers, even a small change in that percentage can potentially have a big impact on how people are processed through the system. Now, the next stage in the process is the magistrate. So when the officer makes the warrantless arrest, they bring the person to the magistrate who determines whether there's probable cause and if so, charges. If there's no probable cause, the person is released. But in instances where people come to the magistrate in the first instance, as opposed to going to the police, there's an option of the magistrate issuing either a summons or a warrant. The summons is like the citation. It basically says, show up to court and answer the charges. The warrant orders an officer to arrest the person and they'll be taken into custody. Every time someone is arrested by a law enforcement officer, they have to be brought before a magistrate who's the first person in the process that sets bail. Now, in North Carolina, we have predominantly a money-based bail system, and that is true even for misdemeanor offenses. Again, we crunched the numbers on this issue, and here's what we found. In 2019, secured bonds, often called money bonds, were imposed in over 66% of highest charge misdemeanor cases. Over 66%. Now there's huge variability at the state, at the county level. In Jackson County, for example, in 2019, they set money bonds in only about 36% of misdemeanor cases. That jurisdiction engaged in bail reform in 2019. At the high end in Dare County, the rate's 87%. 87% of highest charge misdemeanor cases got a money bond. And remember, we just looked at the type of misdemeanors that are in the system. We just looked at the data statewide. It's only about 6.66% are violent. And we have all that data at the county level as well. Now, one consequence of money bonds is that they can lead to wealth-based detentions, even for relatively low bail amounts, meaning that people can remain in jail not always because they're risky, like there's a risk that they won't appear in court or they'll commit a new crime, but because they can't pay the money bond that's required in the case, even when the money bond is set at relatively low amounts. Now, it's hard to get good data about current data about our pretrial populations. We've been doing some analysis on this. We actually released reports recently on 2019 and 2020 COVID pandemic jail populations. But in 2019, we were able to determine there were about 18,000 people in North Carolina jails. It's imprecise because of inconsistent and incomplete reporting. Some of those people are serving sentences. Some of those people are being held for jurisdictions like ICE, but most of them are being held in jail pretrial. Now, I mentioned earlier that the magistrate has a choice when an individual comes to them for charging to issue a summons versus a citation. The summons is the piece of paper, says show up in court, a summons versus a warrant. The warrant instructs the officer to arrest the person. And as we just talked about, once there's an arrest, the magistrate determines bail, and most people end up with a secured bond. In terms of the discretion that magistrates exercise on issuing a summons versus a warrant on misdemeanor charges, the summons is not used that much. You can see the data point there. It's only about 1/3 of cases, misdemeanor cases, get a summons. There's huge variability at the county level. In Yancey County, the magistrate, when they have a choice, summons versus a warrant for a misdemeanor, they only do the summons in about 8.7% of misdemeanor cases. In Greene County, it's as high as 60%. So where you live matters in terms of how you're going to be processed in the system, and then those consequences that come downstream, like going before a magistrate, getting bail, the potential to get money bond, etc. Now, the next step in the process is district court. And in district court, the bail will be reviewed, counsel will be appointed, the case may be dismissed. At some point, a guilty plea may be taken, a trial may be held. If the defendant is found guilty, sentencing will occur. But let's talk about the numbers, how cases get disposed. This is from the Administrative Office of the Court's Statistical and Operational Report for 2018-2019. Here's what I want you to focus on, though. Look at the numbers that are highlighted there. These, on the top row, it shows the cases disposed in district court by guilty plea. And then the bottom row is the cases disposed of by dismissal. You can see that those numbers outstrip the numbers for cases disposed of by an actual trial. So these numbers are telling you something about charging, dismissals, and how cases are processed in the system. Similar proceedings happen at the Superior Court level, either for felony cases or misdemeanor cases for trial de novo, but let's look at the numbers there. There are far fewer cases disposed of in Superior Court than in District Court, but here are the numbers. Guilty plea, no contest is over 63,000. If you add the column before that, that's another 9,200. You can see that those numbers for cases that are resolved by pleas are significantly higher than the number of cases that are resolved by a trial. And that's another factor that plays into how the system works. Now, at the back end of the system is probation, supervision, or incarceration. Here are some quick numbers that I pulled off the Department of Adult Correction website the other day. If Ellen's going to advance the slide for me, there we go. Those were the numbers of people under supervision. I checked today, they changed a little bit. Prison inmates was a little over 30,000, but there are far more people being on probation than are listed as being in the prisons. Now, it's important to note that the back end of the system isn't always the end of the system. That people who are on supervision can have their probation revoked and they end up back in court. They can end up back in incarceration. And sometimes the collateral consequences of the conviction, which can be significant, or the criminal record itself, which can be a barrier to employment, results in the person re-entering the system at the front end. And we'll get back to that momentarily. But that's the simplified systems map. Again, it's not all encompassing. There's one question that's been asked is, do the number of cases represent individual charges or individuals charged or the charges? The numbers that I gave you were actually for criminal charges, but I have information about the number of defendants. When I said that we had about 1.9 million criminal charges in 2019, that represents about 1.6 million defendants. So there are some defendants who are picking up multiple charges, but it's not that far off. I actually thought the numbers would be maybe half, but they're not. So 1.9 million charges total, 1.6 million defendants. The number of cases is a little bit closer to the number of charges. And again, if folks want more information on that, I'm happy to supply it. Does anybody think I left out any steps that are critical to your work in this simplified model? If you do, put them up in the chat box. I already mentioned that some of you may want to talk about the juvenile system, which can in fact be a feeder into the criminal justice system for transfer cases and otherwise. I'm going to give you a second to put something in the chat if you think there's a critical step based on your experience that's missing from this map. All right. Let's transition, and now it's time for you to do some work. What I want to do is talk about factors that influence who enters and re-enters the criminal justice system. In a minute, we're going to talk about factors that impact the actors, but right now we're just talking about factors that influence who enters and re-enters the system. And I'm going to start you off with two, and then I'm going to open it up for you to add others. Here's the first one that I want to suggest to you. One of the factors that influences who enters the system in the first place is what we choose to criminalize. For example, in North Carolina, we delegate authority to local governments to create crimes by ordinance, and they do. One of the most common crimes that's charged in North Carolina, it's often called soliciting alms in a local ordinance. There's a policy choice when a local government chooses to criminalize that behavior. On the one hand, the local government could decide we're going to deal with issues of poverty and homelessness as a social issue, or we're going to deal with it in the criminal justice system. That's a policy choice. Now, we could spend a whole session on how well the justice system changes a person's situation, changes the situation or not, but that is a policy choice. Likewise, it's a policy choice on how we deal with those million traffic offenses. You know, on the one hand, you could potentially say offenses that don't endanger people on the road should be treated in the non-criminal regulatory system, and only offenses that actually result in danger should be criminal. It's not necessarily an all or nothing approach. I'm not advocating it in any way. I'm just highlighting for you that the choice of what you make criminal influences who comes into the system. There's a great question that was asked about any ideas about how many charges are from citizen-initiated warrants. I can't answer that question. It's possible that the AOC can answer it. We tried to do that analysis by looking in this massive database of ACES records that we've created, and it just wasn't possible based on the public information released for us to determine whether charges were initiated by a citizen versus an individual, by a police officer. I do remember when I was working on the North Carolina Commission on the Administration of Law and Justice, that the AOC did have some statistics on the percentage of citizen cases that actually resulted in just dismissals or non-prosecutions, and that number was quite high. So that's a follow-up point perhaps for staff members, but that's a great question. And I see that one of your law enforcement members has noted that some states use an administrative system for low-level traffic violations rather than the criminal courts. I've heard that too, and I've also heard that in some states there's sort of certain number of bites at the apple through the administrative system before it escalates to the criminal justice system. So, criminalization, what you choose to criminalize. Then another issue is the availability of health services, particularly availability of behavioral health services in the community. Most anyone in the justice system acknowledges that a lack of behavioral health services in a community often lands people at the doorstep of the justice system. And the same thing is true with drug offenses. We saw the numbers for misdemeanors and felonies when there are no treatment options, that substance use can drive offenses, not just drug offenses themselves, but potentially other offenses like property crimes that people are engaging in order to deal with their drug issues. So I've talked for a while. Those are two of the factors, but there are many other factors that influence whether people enter or re-enter the justice system. So now it's your turn, and it's your turn. And the reason why we were doing this exercise is every one of these factors that influences who enters the system is a potential lever that you can pull in your work in addressing issues in the justice system. Okay, so go ahead and open your chat box, and I want you to put your ideas in there, and we'll talk about them, and Ellen is going to add them to the board in real time. One person has sent a message mentioning about probation revocation. And that's true. A lot of people actually end up incarcerated for the first time through a probation revocation. And one thing that often is discussed embedded in that issue is the role of fines and fees and the role that they play in that process. So looks like Ellen's putting up probation revocations, and you might want to put up another item about the roles of fines and fees that people are unable to pay and impact their ability to become productive members of society. The chat box is mighty silent. You all came with a lot of good ideas. There was a data question came up about who gets secured versus unsecured bail. I'm guessing that the question was actually asking about who gets conditions other than money bonds, secured bonds, who gets conditions like a written promise, custody release, or unsecured bail. Really hard to determine that issue. We have some data on that on some bail projects that we're working on, and happy to explore that with folks if that is an interest. Eliminate, a suggestion came up about limit or eliminate citizen initiated warrants. So let's just think about for a minute. How would you, I know we got that from I believe we got that from our prosecutor member. Is there a way that you would describe that factor there? Because, sometimes people say like the lack of other resources to resolve conflict. Like I've heard it suggested maybe when an individual, they should have to go through some kind of mediation or something to resolve private disputes. Any clarification on that? That seems to me to be a great policy. Yeah, but in terms of thinking about drivers into the system, it looks like we've got failures to appear. Representative Moray mentioned that, who of course has been in the court system, and it's true. We talked about how the bulk of the criminal offenses are misdemeanor offenses. Well, you can end up in jail on a misdemeanor offense if you get charged by a summons or citation and you miss a court date, or you show up a few times and then miss a court date. You can end up in jail for that lower level offense. What else have we got up there? Overcriminalization has been noted by one issue, and I saw Tara Callahan posted that. But Tara, I'm wondering, given your work on Second Chance, do you have other issues about things that drive re-entry into the system?
And certainly, obviously my work with you, Jesse, has been focused on the juvenile system and how, with the school justice partnerships and other efforts to kind of keep kids out of the system just from the start to prevent the likelihood that they're going to remain in the system throughout
And of course, with the Second Chance Act, one of the things that was meant to be addressed there was the criminal record, which can be another factor, Ellen, to potentially put up on the board here that causes a person to re-enter the system when that criminal record becomes a barrier to someone serving in the military, going to college, getting a job, etc. And I see we've got some comments that are weighing in on some of the policy choices about citizen warrants and if you were to eliminate them, the pressure it would create on police. But some more factors that influence whether a person enters the justice system or not. So we've got a comment about targeting particular neighborhoods with policing. I'm going to say, I think that's a great point. I think it goes a little bit more to factors that influence actors in the system, but I think potentially embedded within that point that came up in the chat is what's the political and sort of philosophical atmosphere in your community? Is it a community that's incredibly tough on crime and wants law enforcement and votes its leaders for law enforcement to engage in things like broken windows policing and the like? So political environment that folks are operating can be another issue. The influence of victims came up. That surely that creates an appropriate, in many instances, pressure and sometimes a challenging pressure for prosecution of perhaps some low-level issues, but victims' interests are another one. I know we've got some people on the line that are involved in re-entry issues, so I'm surprised that there haven't been some issues around some of the core societal issues that often come up in re-entry. What do you think about issues like availability of education and housing as driving people into the system? Do those seem like factors that are relevant? We talked about the common offense of begging as an ordinance crime. We've got a comment about trauma driving people into the system. That probably relates to the health services. You're the task force, so you can agree or not. But when people don't have those behavioral health services to deal with issues that are causing them to act in certain ways, certainly that can lead to criminality. Education has come up as an issue there. We have mentioned a little bit about the criminal record. There's also the issue of the collateral consequences. All of the other things that people are excluded from when they have a criminal record. That's another potential issue. Economic opportunities. I was wondering when that was going to come up. Jobs and economic opportunities. Clearly, we know the role that plays in recidivism. I think that we've really hit on a lot of them. When I do this with other groups, sometimes issues like family stability comes up. Sometimes issues like hope and faith and a sense of belonging in a community comes up. It hasn't in this group, and that's fine. And there's some interesting comments coming in about victims and perhaps support and issues that need to be addressed around victims. But looking at the clock, let's transition a little bit and let's talk now about some factors that influence the actors in the system. And again, I'm going to throw out a couple, and actually someone just put one in the chat that actually relates to this, and it's the legal framework. There's the constitutional framework, and a lot of those rules are clear, but some of them are evolving, like in the current constitutional litigation around bail right now in Alamance County. There's also a statutory framework, the framework that says what a magistrate does. And then there's a comment that came up in the chat there about restorative justice, that are, the legal framework that we operate in doesn't necessarily include that, component. So the framework obviously impacts the system. And of course, one of the things you're probably going to be doing is thinking about whether there should be changes to that framework. Another thing that influences actors in the system is accountability. And some actors in the system are accountable mainly in the political process. like judges and district attorneys, although there are other rules like judicial standards and state bar rules that may govern their behavior. Other folks like our police chiefs may be responsible to town leadership. So accountability is a factor that influences how people behave in the system. And I know one of the comments came up about political selection of magistrates. And there's also the separate issue of accountability of magistrates that come up. These are issues that impact how people behave. And again, every issue that impacts who enters and how people behave is a potential lever for you. One more, and then I'm going to throw it open to you for your ideas, is the issue of data. In many areas, it is really get good data about how the criminal justice system works, about incidents of use of force by police, about the racial demographics of who's sitting in jail today and how long they've been there. We're working to mine that data wherever we can find it, and others are doing it well. But I'm betting you've heard the expression, if you can't measure it, you can't improve it. Now, I don't say that to give folks an excuse to say, well, we can't measure it, so we can't improve it, because I think you can do both. You can improve it and put in place accountability systems to get relevant data. But this is the availability of data to evaluate how the system functions really impacts the whole system. It impacts at the regional, at the county level, and the individual level. But what else? What are the other factors that influence how people in the system behave? Someone mentioned crime rate in the chat box. And I'm sure that's true, that there are these sort of externalities that the individuals themselves may not have direct control over. And I wonder if that also relates to the issue of politics, in that so many of our people in the criminal justice system are actually elected, and the voters may choose to focus on those issues. Community expectations and norms, again, like for me, that falls within political. Maybe the person that suggested that means something different. Clarify for me if you think so. But other factors that influence people in the system and how they work. What about
as it related?
Yeah, go ahead.
I'm sorry. As it related to the comment about crime rate, that was for the actors who actually get involved. For police, a lot of what we're doing is driven by the crime rate and the pressures to either control the crime rate in certain areas or to have a direct impact in certain areas.
Mm-hmm. And I think also, that kind of gets into the issue of, local policies about, if there is a crime rate that community members are concerned about, what the policy decisions are about the best ways to address those issues. Accountability and transparency have come in. Race. I'm surprised, given the nature of the conversation, that actually didn't come up on the factors that feed into the system, the issue of bias and issues around race. But I think clearly issues around bias and race do influence how people engage, the people who are involved in the system behave. Legislative mandates, reduction in discretion came up in the chat box. I think that authority and discretion are huge. Authority and discretion are huge factors that influence how people behave. What's the scope of their authority and what's the scope of the appropriate discretion? Training just came up. That's another one that I had on my list. I also have policy on my list, and that refers to policy at the state level, but also local policy, the local policy that the senior resident issues about bail, local policies that police departments have. Culture just came up. I also had that on my list. That's another issue that impacts how people behave in the system. It was listed here as blue silence culture, but I think there are a lot of cultural issues that impact how people how people behave.
Professor Smith,
Yes.
this is Henderson Hill. I think one comment I would make is we're still sort of experimenting with this system of communication. And so I think the absence of race as being a prominent feature of our comments is in part, we're just still trying to figure out how to engage in this conversation. I think we'll probably get more accustomed to it as these task force meetings go on. I think one of the questions that I've been struggling with is where we fit into this conversation, some of the discretionary calls that really bring people into the system. Where do we choose to look to conduct policing activities? And what are the disparate consequences of the decision to focus on one neighborhood and to avoid college campuses? When it comes to drug use, I think every consistent report shows that the drug use across races is almost identical. Whether you're talking about the African-American community, the white community, the Latinx community, but the arrest rate and the prosecution rate is significantly higher. And that reflects choices, policy choices. Mm-hmm. And I think one of the issues that we're going to be struggling with is how do we identify those policy choices? How do we bring the policymakers into a greater level of accountability for those choices, and how we put them before the community? So we're making these choices with our eyes wide open. But this has been a very provocative conversation. Thank you for leading it.
Sure, and this isn't meant to bind you in any way. This is just meant to get people thinking about these issues before you have your breakout groups this afternoon. I do want to mention something that Jim Woodall mentioned. As a prosecutor, I'm not surprised, resourcing down in the bottom. Resourcing really impacts how the system can respond and how effectively it can deal with issues. This is an issue everywhere. I hear this a lot in our rural communities. I have gotten a message that I'm getting the hook. I think we've raised a lot of really important issues, and I'm going to stop and let Cammie pick up, and she's really going to focus you on some of the racial disparities that have been found. Reach out to me at any time. I'll be back in a later session for some more discussion. Thanks, folks.
Good morning. My name is Cammie Chavis, and I am a professor of law, director of the Criminal Justice Program at Wake Forest University School of Law. And I have been studying racial disparities in the criminal justice system with a particular emphasis on law enforcement or the organizational change of law enforcement. There my slides are. Really, my presentation is really going to drill down and focus on this issue of race. So, how did we all get here? I'm going to move to the next slide and really discuss the roots of racial disparities in policing. And I'm sure you have all heard this, but police departments, as we think about them, are really kind of modern creations of the last 100 or so years. But we know that many of them began as slave patrols and the night watchmen in the antebellum period. We can move forward to Reconstruction and think about the role that law enforcement played in the complicity, for example, with lynching. Unfortunately, a lot of times law enforcement officers either actively participated in those or turned a blind eye to those who they knew had committed crimes. We move forward to the civil rights enforcement, and if you look on the next the next slide here, I mean, this is an image that's really familiar to lots of us. When we think about the civil rights movement, folks who were advocating, who were protesting unjust laws were met with law enforcement who were charged with enforcing those. So in the modern era, and just to go back and think about we're going to skip this slide, but in the modern era, it's really the war on drugs versus the opioid crisis. When we think about the war on drugs, really with the African American community dealt with clearly from a criminal justice law enforcement point of view, whereas the opioid crisis we know has really been treated more of a public health issue. And there, what doesn't matter what type of drug it is, they were both illegal or illicit drugs, but they've been dealt with in a very different way. And we have statistics to bear that out. So when we think about our modern law enforcement agencies, we know that many police departments lack the diversity and fail really to represent the racial or ethnic makeup of the communities they serve. That would be a difficult feat to have. We're not saying necessarily that you need a proportional representation, but when you think that in 35 of 85 jurisdictions where you have racial minorities making up the single largest ethnic group, often they are policed by a police force that is the flip side of that, with very few minority officers. And I just say this to say, if we think about the visuals and we think about some of the things that we've heard lately in the discourse, it is that visual that makes law enforcement agencies look more like an occupying force rather than a guardian force. And you've heard this guardian warrior style of policing, and we'll talk a little bit about that in a moment. Moving on, when we think about, and so with all of that, and we're thinking about all of the roots of some of the disparities that I'm going to talk about and some of the tensions that have arisen, there's no shortage of solutions, and you all will come up with your own solutions and those tailored to the issues that we have here in North Carolina. But of course, there's when we think about how to address some of these disparities, community policing, community control of law enforcement agencies, which looks different than community policing. There's the defund versus reinvest. What do we mean by those terms? Demilitarization of police forces, de-escalation. So there's a whole menu of things to think about. And many of these actually have been, and one thing that I want to flag too is that if we think about the 21st century task force of policing, President Obama's 21st century task force included some, not all of these as pillars, but one of those was officer wellness. When we think about police use of force and police violence, that's something I think that is not always on the table, but and yet it is very important, and we know that matters. But anyway, these are just some of the things that have been raised throughout the nation. How do we keep police officers accountable, and particularly how do we begin to address the racial disparities? So I'm going to move on here to thinking about racial disparities in police stops. By the time I'm done with my presentation, you will see that racial minorities are overrepresented at every aspect of the criminal justice system. And so we know that entry into our criminal justice system begins sometimes with, in investigation, elsewhere, but for the individual, it may begin when you are stopped by law enforcement. And so everyone is familiar with what was happening in New York City with with stop and frisk. And even though we don't often call it stop and frisk in outside of New York and some of the larger cities, we know that these programs do exist within many these policies exist within many law enforcement agencies. So, and the racial disparities in police stops were just so disproportionate. When you look at that, the figure 54.8% were Blacks, 31.8% were Latinos, and there you would hear anecdotes from folks in New York about being stopped multiple times a month, and so much so that there were more stops conducted than the number actually of people in the population. That means a lot of stops were happening, and the vast majority of those who were stopped were Black or Latino. And I think what's really interesting is that, well, you can have a law enforcement policy that is, directed at, whether it's finding weapons, but here it was only 2% of frisk actually resulted in a weapon found. So that's a lot of inconvenience for certain groups, a really heavy burden to bear for certain groups of people, and not a lot of law enforcement benefit there. And certainly when we think about this, the lack of trust that it creates between citizens and law enforcement, this is at the root of that. And what do those numbers look like in actually, this is where I will go back. Ellen, if you don't mind going back just a couple of slides, I had something out of order. But what does that look like for us in North Carolina? Racial disparities stops in North Carolina. I'm sure everyone is familiar with Frank Baumgartner's analysis of the traffic stops in North Carolina. So much of this data comes from his research and analysis. But in Greensboro and Asheboro, police departments twice as likely to search Black drivers. North Carolina state troopers 3 times more likely to search Hispanic drivers. Officers 250% more likely to use probable cause. So that heightened standard of probable cause versus the Terry reasonable suspicion as justification to search Black motorists. So that means that there is something happening within that officer's calculation as to, well, how am I going to make this a proper stop? I'm going to say it's probable cause and use that standard. So Black drivers 43% more likely to be arrested than whites in North Carolina. So that's just some of our numbers. But then I'll go back down to, have to go back to slides. I apologize for this, it was a little out of order, but so, and nationally, the same is true. Nationally, African Americans more likely to be stopped by law enforcement. I mean, most jurisdictions that actually study this, and we'll talk about the lack of data, but the Stanford Open Policing Project found that across all jurisdictions, law enforcement officers stopped Black drivers at higher rates than whites. And again, this remained true even where researchers accounted for the age and gender of the driver. So not only are racial minorities stopped more often, but as you'll see on the next slide, they are also subjected to searches more often. And that was the data that I was showing you in North Carolina. So if we move on to the next slide here, sorry, African Americans, I'm sorry, you can go back one more, thank you. But they are subjected to more searches. And again, when you're applying a statistical model that's accounting for differences in other outcomes, the discriminatory pattern persists. And that means that police appeared to require less suspicion to search Black and Hispanic drivers, according to that particular study. So this bears, we see it nationally and we see it locally in North Carolina. So when you are stopped and you're searched, what happens, and you're arrested more often, what happens during these stops, searches, and arrests? So when we think about uses of force, police are more likely to use every single type of use of force, all of the use of force that they have available. We think about law enforcement agencies will often have a use of force continuum, starting with the officer placing their hands on someone, and this spectrum goes all the way to using your service weapon. You'll see here that with Blacks in similar situations, it was always it's always a disproportionate amount of force, whether it's hands or pushing into a wall, the use of handcuffs during encounters, when you're stopped and the officer draws their weapon. Again, more likely to use force against Blacks. If you we'll go to the next slide, and we'll see that this continues even as we go to more uses of force, pointing the weapon, using spray, pushing to the ground. Now, so that's certain uses of force. If we again advance to that the next slide, what does this mean for the use of lethal force? So lethal force, and this again, when we think to many of the reasons that you all are sitting where you're sitting and listening today, we know that there are national instances that have sparked renewed debate about this. But unarmed African Americans, nearly 3.5 times more likely to be shot by police than unarmed whites. Non-suicidal, so when we think about Black men who are armed and police are not necessarily responding to a mental health crisis, they are more likely to be fatally shot by police officers than whites. And so some of the anecdotes, again, around this are really troubling. And so, and I say that just to say, when we're thinking about community distrust and what things look like to racial minorities, you see Dylan Ruth, who we know was a violent person and who killed 9 people, yet taken peacefully away, and then juxtapose, and this is of course in South Carolina, and then juxtapose that to Walter Scott, who was leaving, running from the scene of a traffic stop and was shot in the back. So those images are seared in the minds of many community members, and that is why it can sometimes be difficult, of course, to form the partnerships law enforcement needs to form in order to have public safety concerns. While people of color make up fewer than 38% of the US population, they make up about 63% of unarmed people killed by police. So there's a Guardian study, I hear a comment, there's a Guardian study that found that while more white people in total were killed by the police, when you correct for the percentage of the population, all of the people of color were more likely to be killed by police. The white people, while people of color made up fewer than 38%, 63% of unarmed folks killed by police. And that is from a Guardian study in 2016 that I'm happy to share. There's also a 2020 statistical study from the National Academy of Sciences of the United States that suggested, again, that is the suicidal, the figure there. So that is from a 2020 study. All right, so let's go to our next slide and think about Again, we can show, and I just picked a few studies nationally, but San Francisco, African Americans, again, 42% of all non-consensual searches or stops, of all of the people searched, African Americans and Hispanics had the lowest hit rate. So, and what does hit rate mean? That means, what was contraband actually found. So when we think about the law enforcement purpose or benefit, we're thinking about that. And so even though they're stopped more, they actually have the lowest hit rate. And in Ferguson, Missouri, again, 90% of documented instances of use of force were against African Americans. And this is one, Ferguson is one of those jurisdictions that I was talking about where the racial makeup of the officers or of the law enforcement department at the time, this was around when Michael Brown was shot, at the time was really flipped. A majority of African American community policed by a majority white police force. Every single documented instance of canine bites involved African Americans. So what does this look like for us in North Carolina? From 2013 to 2019, and I did, just so that we're clear where this information is coming from, this is coming from mapping police violence, and they show that 204 people from 2013 to 2019 were killed by police officers. This is an interesting, if you go to that website, you can filter the results by law enforcement and agency, and you can also filter the results for race and gender as well. But there's also been a little bit of criticism. Some of you may have seen in the News and Observer recently that what do we really know about how police officers in the state are using force? And this article says most agencies won't say, but data, of course, very, very important here. So if we kind of go back to our national police figures, and I'll just look at this. This is really interesting. We see that police violence is changing over time. So police killings have decreased in cities, but have increased actually in suburban and rural areas. And we know this by the zip code and the population density there. And police deaths by police are increasing more. More people so far in 2020 than they did in the period in the last few years. So what we might begin to think about what is changing there. Okay. So I'll keep on with the thread of police use of force, and again, we'll just go through here. Again, these numbers are from 2016. Whites, and these are national numbers, 54% of police shooting victims, Blacks represented 28%, Hispanics 18%. So that's even, and I'm sorry, again, I think this slide is out of order, but the other numbers that I gave you show an increase. But still, the point is that we see the disproportionate use of force against African Americans and Hispanics. Okay, so then the next slide, when we think about how officers arrive at what I think is interesting about this is when we think about the 911 calls and the plotting the use of force involving guns across neighborhoods. white officers were more likely to use a gun than were Black officers, and were more likely to do so in predominantly Black neighborhoods. So a lot of times folks will ask me, well, does this mean we need to diversify our police forces? Are we? The truth is that we know that all officers, whether no matter the race, there's a disproportionate use of force against Black people. And so my response has often been, well, it's not necessarily the race of the officer, but we really need to be looking at the law enforcement agency, at the organizational culture and the policies, because any officer can become a product of their law enforcement agency. And if there are not good policies or good supervision, discipline, good training, then we could be looking at a problem or an issue. So with that, I think we're going to turn back to our map here, Jesse's map, and thinking about, again, so I've talked a lot about policing and a lot about the disproportionate way that African Americans, Latinos are stopped, how they are searched more often, when they are searched, when they're stopped, force is used more often, and all types of force are used more often. But what does it look like after that? So we think about arrests. African-American juveniles are twice as likely to be arrested as white juveniles. African-Americans represent, again, 38% of those arrested for drug offenses, even though that is out of step with their numbers in the population. And African Americans are arrested at rates 9 times higher than the rates for whites. And so, although Black individuals are more likely to be arrested for drug-related offenses, they are less likely than their white counterparts to actually use the drugs for which they were arrested. So we're just seeing, again, some enforcement issues and differences there. That's nationally. Let's move to the next slide. And so what happens after you're arrested? You can go to court. You can either be detained or released. But we know in large urban areas, again, this is nationally, Black felony defendants over 25% more likely than white defendants to be held pre-trial. And here, I won't go through all of these statistics, but we also see some gender differences. Young Black men are about 50% more likely to be detained pre-trial than white defendants. Black and brown defendants receive bail amounts that are twice as high as bail amounts set for white defendants, and they're less likely to be able to afford it. And so we know what that means is that we need that more of those folks will likely sit in jail pre-trial, and then there are all types of collateral consequences and the impact that it has on their ability to participate in their defense or that type of thing. So racial disparity, and they lose their jobs, and then even if they go to trial and are found not guilty, they've suffered all of these consequences. So there are definitely racial disparities nationwide in pretrial detention. If we move to the next phase, this is, and I apologize if this is difficult to see, but charges by race. So for violent offenses. And again, these are all controlled for the same thing. For violent offenses, we see charges by race to be more severe for Black, non-Hispanic individuals. And the same thing is true for violent offenses, drug offenses, and driving-related offenses. The severity of charges. let's go to our next slide. And so the severity of the charge really has an impact on the sentence that you might receive. Black males receive sentences in nearly 20% longer than white males who are convicted of similar crimes. So we know, again, this is one of those points that typically if there is some discretion on the part of the decision maker, that discretion may be leading to some disparities. But I would suspect that even where you don't have that discretion, even if you have, you're bound by some guideline, again, because of all of these other disparities, the more, arrests and convictions and things like that, folks' resumes, I call them the criminal resumes, tend to look different. You have
Professor Chavis, so sorry to interrupt, but can I give you a 3-minute warning? Because I would really like us to be able to take a break at 11:30.
Yes, I am ready to do that. I have just 1 or 2 more slides.
Awesome.
And the severity of charges, 100-to-1 disparity between the crack and powder cocaine. We've heard about that, and that of course has been remedied a bit, but it is still not 1-to-1. In the federal system, we know that 60% of folks who are receiving life without parole are Black. And again, 42% of defendants who are under the sentence of death are Black. And so the next, and actually what we can do is, again, because I definitely know everyone's ready for their break. I'll just show a couple of more slides. And again, this figure here shows how many people are incarcerated in the United States and for what offenses. But if we move to the next slide, you'll see, and of course we know that 38% of the federal population was Black, and 50% of the federal population is white. And so again, those figures, when Blacks are about 13% of the United States population, that's a really, really high figure. And then I just want to show the North Carolina figure. So the same is true in North Carolina. Whites in North Carolina, whites are underrepresented in the incarcerated population, while Blacks are overrepresented. And again, the next slide just shows the life without parole. So before we move to the break, just thinking about why all of this is important. Of course, it's important to think about whether there are disparities, and we can have conversations and arguments about whether these disparities arise to the level of the Equal Protection Clause. Did we show some intentional discrimination? But the point is that Blacks in North Carolina and in the nation are receiving more jail time, I'm sorry, I don't know that for North Carolina, but are stopped more, searched more, are bearing the burden here more. And so we know that once you're convicted, and we'll just go to these last 2 slides, once we know that you've been convicted, you lose all kinds. There are lots of collateral consequences of having any criminal conviction, but particularly a felony conviction. And these are actually the final slide here shows North Carolina statutes that talk about some of these things, and some of the things that can be denied: professional, occupational licenses, things like that. And so really, and I think this just goes back to Jesse's point of when we have these collateral consequences, and then it starts a cycle of, and then you're not able to get a job, and then everything just goes into it. Okay, thanks.
Well, thank you both. Thank you, Professor Chavis and Professor Smith. We're going to take a 10-minute break, maybe 9.5 minutes, come back at 11:40, and I promise we will finish 1 o'clock or before. So thank you. Okay, well, I have that it is 11:40. So it's challenging for me to figure out how many of you are back, but hopefully most of you are. And I will now turn this over to Professor Smith and Chavis, who are going to lead us through identification of policy options to eliminate racial disparities where they exist. So.
Welcome back, everybody. So this is really a session for you to be adding most of the content. The idea here is to use this time before you go off to your task force for you to start to put up on the board policy options that the task force as a whole or the working groups can consider. You know, you came to this group with experience and ideas. You actually have presented a whole bunch of ideas already in the session today, but what we're asking you to do is to start putting in the chat box some policy options that you think should be for consideration by the task force. The idea isn't to fully vet them. They don't have to be fully baked, but they should, you know, be complete enough that people understand them. And I'm going to go ahead and throw out a few that have already been mentioned in the chat box. And I see Ellen's already typing. Dealing with the issue of private warrants. Those are the sometimes called citizen warrants came up. Officer diversion came up in the chat box as a policy option. Restorative justice also came up as an approach to dealing with conflict in our system. Another thing that has already come up is guardrails on discretion. This was mentioned a couple times in oral comments and in the chat box about the role of discretion. Police culture was raised in the chat box as a policy option, as was the criminalization of traffic and low-level offenses. That was raised as an potential policy option. Another thing that I saw in the chat box was examining status offenses. Those are things like habitual felon that can really ramp up some sentencing consequences. I also saw in the chat box questions around data that's available in the criminal justice system. And I also saw in the chat box the policy issue of officer training. Those are the ones that I caught. I may have missed some. Someone has already mentioned transformative justice. I'm not familiar with that. You want to help folks understand what you mean by that? That came from.
I will post the link because I think it's a deeper conversation.
Great.
Yeah.
Great. Okay. Is it something that's related to restorative justice?
It's a step beyond restorative justice. They're not the same. They're two different things.
Terrific. Thank you. Okay. So we'll get that up there, transformative justice. And it looks like we have from a former district court judge about raising the minimum age of juvenile jurisdiction from 6 to 10. I'm guessing Representative Moray, that relates to the sort of juvenile justice to criminal justice connections there. Cami, feel free to take over on some of these. I see there's some that are coming up in the chat box around policing. Do you want to go through those and clarify them if we need to?
Yes. And I was going to say, it's interesting if we kind of go, if we go chronologically with our steps in the criminal justice system. One of the things I see, of course, is I see police culture, and so why don't we, and we can, and folks can continue to populate the chat box, but let's. When you're talking about police culture, the commenter, the person who mentioned that, or anyone else, do we want to say more about what we mean by police culture? There's a lot of different dimensions to police culture.
Yes, this is Kerwin Pittman. I commented on police culture, and what I exactly meant by police culture, meaning individuals that set the tone of their department. So we know that different law enforcement agencies, the tone will be set by the head. So when I say police culture, I mean it in that sense. Can we look into maybe training the sheriffs and the police chief in different tactics to kind of facilitate a more less biased atmosphere? So I know that the leadership start from the top down. In police culture, particularly, I was speaking about the blue code of silence. If we can maybe do some type of transformative strategies around implementing recommendations to kind of break this silence, because we know silence means acceptance, and this is how George Floyd was initially murdered.
Right. So if we're thinking about different dimensions of police culture, and I think what you are particularly identifying is the blue code of silence. That's absolutely something we've seen it mentioned by judges in court documents, and it's something that other jurisdictions are taking up as well. When you do you provide whistleblower protection, for example, when you have an officer who we have to think about, I think, what is preventing officers from talking to their superiors or to other officers when they see misconduct or allegations or something like that. So that is certainly something to take up. That's again one dimension of police culture. And in other aspects, what I've thought about is when addressing that, you also have to address the idea of group loyalty, right? So that group loyalty that officers have, that's important. It can be very important for them on their job, but then what do we do when it turns perverse? So so that's one aspect of, or were there other aspects of police culture other than the code of silence?
Hello, this is Chief Davis. I have a comment.
Hi, Chief.
What I would say about about police culture is that, culture takes, several years sometimes to develop to be a culture that in turn takes several years to break down as well. And, I have had several situations where I realized that the action of the officer had a lot to do with the culture of the department as opposed to any other influencer. And it starts really at the very, very bottom level with supervisors to hold them accountable for ensuring that those officers comply with various policies and procedures, as opposed to the slap on the hand, or I don't want that that officer to be mad with me, and for them to understand what their role and responsibility is as it relates to accountability. And I have a situation right now that is exactly that type of situation that had a lot to do with the culture of the department and trying to ensure that supervisors are held accountable for officers' action. Thank you, Ms. Chavis.
Yeah, so there are a lot of different things there when we think about police culture. If you have an officer who's a repeat offender, and we don't, and the others in the department don't see that officer being disciplined or taken to task or in some manner, then they believe that, well, I can do this too, or I can get away with it too, or this is going to be tolerated. And in some egregious instances, it moves from really tolerating that conduct to almost encouraging the conduct, particularly when you see supervisors. And I think we've seen some modern examples of that, some very recent examples of that. So, and that is related, I think, to the idea of the code of silence, because then if a person says, well, that's my supervisor that's doing something wrong and I'm going to be retaliated against. So how do we protect those folks from being retaliated? And I think that I see officer training related to that. Does someone want to talk about officer training and say more about officer training?
I'll jump on that. Officer training is certainly critical because that's how you start your culture. And sometimes when an agency can do more internal training with their new officers and new staff, they can indoctrinate that person in the culture rather than having them trained outside. What we also see in North Carolina is a lot of officers who come from other departments or other states. And while that is good and it brings experience, it also brings culture from wherever that person came from. So in some cases, we have to deculturize that person from wherever they came from and re-indoctrinate them with what is appropriate for our community. And those are important things that certainly have to be reinforced from the top, as was mentioned, but also the most important day-to-day reinforcement of that comes from that first line supervisor. So supervisory training, leadership development from our supervisors is critically important because they are the ones that are going to enforce it. And I think we have to be careful not to paint a broad brush over anything because there are some great examples of where things are working well and great examples of where they're not. And cross-pollinating those ideas are important. Some agencies get more internal complaints through their internal affairs process from their supervisors than they do from external, from citizens, which says the accountability culture is strong and that supervisors are doing what they are expected to do in monitoring and holding accountable their staff. And where that occurs and where we can make that the culture, we address not only the issue of officer training and accountability, but we're carrying forth that message that starts from the chief or the sheriff to have a functioning organization where the loyalty is to the community, to the Constitution, to the oath of office, and not to the department, the profession, to the partner, and so on.
I'll just add a couple of things about training because I see in the comments, and I know we want to get to some other topics, but when we think about training, there are different aspects of training. Are we talking about use of force training? I see in the chat racial equity training, and there's been a lot, implicit bias training, those types of training. And then, so when we're thinking about training, the issues are who are we bringing in to train? How often is this training happening? Is this training required? And all of the different things to think about with training. And I just wanted to point back to one thing, because I think data, and we really just to drill down, and data could almost be, we could overlay the idea of data with all of these topics. If we don't have the data, right? And because the last person who spoke mentioned how some jurisdictions are doing really, really well. And so when we have data, it helps us. We can know what's going right, and we can learn from the places that are going right. But when we're working in the absence of data, that's difficult to do. And there was a comment by Mr. Pittman in the chat earlier that talked about the North Carolina use of force data, and that is very difficult to find. And I have not found a central place where that's located. And so, and in and of itself can be an impediment to accountability. So Jesse, did you want to?
Well, I just wanted to note there are lots of other ideas that are coming up in the chat box. We've got alternatives to arrest. That would be at the pre-charge stage. The training issue that's on the chart right now talks about officer training, but lots of people are talking about training for multiple different types of judicial officials, raising all the same kinds of questions that you're asking. There also are a number of comments in the chat about those sort of back end issues that feed into the front end, the issues of fines and fees, restoration of driving privileges. There's an acknowledgement in the comments about, the transportation isn't a luxury, it's a necessity in many parts of North Carolina. So it might be worthwhile to get some of those issues up there as well.
This is Sheriff Clemens. I had a comment that I wanted to make as it pertained to training. We're hanging our hat on the training piece, which we should. to better educate our officers. But understand this, all the training in the world is not the root cause of all this violence. We have well-trained officers, not only in the state of North Carolina, but in this nation. And you can sit them down and put them in the classroom all day long and pump all the knowledge you want into their heads. But if you cannot judge what is in their heart and what is coming out from them in the community, all the training in the world is not going to make a difference. The training is not the issue. Yes, to have better trained officers, maybe the instances of use of forces and things will not happen. But however, we have to also be able to judge that particular officer, that person that we're putting a gun and a badge on their hip and putting them out there in the community. Let's not forget that the individuals that we're bringing into this business are from these very communities that we police. We talked about the disparities and how law enforcement officers and the encounters in the community are with predominantly white officers. Well, here's what I'll tell you. As an African-American sheriff and as an administrator, where are the minorities? The lines are not long. The lines are extremely short. We're looking for females. We're looking for people of color. We're looking for people of brown. They're not coming into our offices and filling out these applications. The question is, how do we reach out to them to be in a position to have our sheriff's offices and our police departments look like the communities that we're policing? These are a lot of issues that we're dealing with, and that plays an important role. But the issue with education that I see in training is awesome. We have to have it. It is a must, but we still have to spend that time understanding what is in his heart. We know what we're putting in his head, but we don't know what's coming out of his or her heart until these tragic situations happen out in our community. And by that time, it's really too late.
Yeah. Yeah. So what I hear you saying is that, you know, while training is important, there's perhaps an over reliance on training without looking at what you're calling some of the root causes. And so what I don't see up here, but what I think you've articulated is perhaps hiring and taking a look at the front end the front end of the process and thinking about hiring. It's much easier. I always say it's much easier to hire, to get the right person in the seat than it is to train out any propensity for violence or bias.
Let me interrupt you, because there was something that the Chief Litney said when you're redirecting those individuals. Here is something when you talk about the culture of law enforcement, and those of us that have worn a badge at some point in our career have heard this with our training officers when we come out of rookie school. They said they have taught you what the books say and what training says, but now we're going to teach you how to really police. See, that's a part of that culture that we tend to forget. Everything that they're learning in the classroom that they could put to use, it changes when they cross the threshold of those agencies and now going out there to police the public.
And that policy issue might be recruitment and hiring as well.
Let me just tag on to something Sheriff Clemens just commented, the difficulty of recruiting the right folks. One of the obstacles to that are the collateral consequences of over-policing certain neighborhoods. And so certain arrest records will disqualify perfectly good applicants from the communities that are being policed. And you go outside those communities, and I have, sort of personal knowledge from the process in Mecklenburg County, where broad swaths of Charlotteans are excluded from the police and fire departments here in Charlotte, but folks from communities outside of Charlotte, outside of Mecklenburg County, with a different arrest policy, a more friendly arrest policy, are not disqualified, don't have those disqualifying arrests and convictions. And therefore, they will populate our recruiting classes much more heavily than native Charlotteans, folks from the community. And so I think one thing that we've got to address is the consequence of these collateral consequences that have been around for generations and how it impacts the pool of applicants.
Also, too, the piggyback on that, Mr. Hill, also, too, it falls upon us as a community and as a responsibility to educate these kids on those possibilities of what can happen when you take those particular actions. A crime is a crime is a crime. And I understand that there are levels of that crime, but we also have to educate our communities in these are those disqualifiers that can hurt you, whether you're trying to get into the military, whether you're trying to get into college, whether you're trying to get a job that can perpetuate a family. So we in the community also have to make sure that that message is getting out there to help prevent these kids from making those bad mistakes. We all have made mistakes. Some of us have made mistakes that would have prevented us from getting in the business that we're in today and anything else. But because of that opportunity or that second chance, we got that. And we're not always giving that to the individual from our community. So I think that we have to work extremely hard also to make sure our kids understand. What I tell people in our community is this, when I'm speaking to the parents and to the folks and grandparents and this, that, and other, and teachers, I said, we have a responsibility of making sure that our students have more classmates than they have cellmates. That is our responsibility to educate and make sure that they understand what their options are, and let's not squander these options. So it's a lot of work that has to be done in the continuum, trying to change that of the past, but it's a lot of work that we have to continue to do. And as we all are doing today, our part in the community, but we need to bring everybody together to work on the same issues that we're dealing with in society.
Yeah, and I see that Alan is adding the criminal record. I mean, there's collateral consequences, and there's the issue of the criminal record, and even people who get arrested, and that can be a barrier for them doing all kinds of things, including being involved in the law enforcement system. Cammie mentioned also the data came up before, and there's lots of comments about data needs here. And I wonder if folks want to just spend a couple minutes talking about what they see as the biggest data gaps. I mean, we've seen stuff about law enforcement officer misconduct, performance of magistrates. What are your thoughts? You're in the system, you're involved in the system. What are your thoughts about where the biggest pressure points are, where better data would help address these issues?
I think one of the things that we see pretty regularly is a comparison against census data. And when that is on a large scale, it may have more applicability. But when it's on a small scale, like one municipality, it's often not accurate. Census data does not follow jurisdictional lines. It's either census block or zip code. And census block tends to be across jurisdictional lines. So, and if it's zip code, it doesn't follow city limits lines at all. So trying to compare anything to census data on a small scale doesn't generally lead to accurate conclusions. On top of that, when we're talking about things like traffic stops, that negates the fact that there are people driving in and around our state, our cities, our towns, and our unincorporated areas who do not necessarily live in the area they're driving through. So as a result of that, an officer may interact with people from all over and make decisions based, and hopefully based on behavior rather than on demographic, but then it's compared to demographic of that municipality. So there needs to be a better way to figure that out. The traffic stop reporting form itself, while it's been in place in North Carolina for many, many years, does not give us the data that we need to really make informed decisions as administrators, and to really look for, is there a problem in our agency or not? Something as simple as, is that person a resident of your jurisdiction or not? That checkbox would be helpful. The reason for initial observation would be helpful. So why did the officer focus on this particular vehicle? Was it a violation? They were speeding, registration was expired, any of those things that were mentioned before, or was it something suspicious? Was it something discretionary versus based on probable cause? That level of information, I think, will help us drill down the data enough to make better informed conclusions than I think what we have now.
So there's the data question. So what I'm hearing is we, you know, and again, in North Carolina, fortunate to we have that form, but really improving that for better use for law enforcement. And then when we think about data and other gaps, there's the traffic stop data that's useful. I see in the comments a database of law enforcement misconduct complaints, fines. You know, there have been some states that have made, you know, personnel records public. Like, so what about when we're thinking about data as it relates to law enforcement, other aspects of law enforcement conduct?
One of the topics that has been going on in a nationwide discussion is a national decertification database. There is not one right now. So in North Carolina, I believe we have a very good system with the state and the Criminal Justice Standards Division, in that when an officer leaves employment, we have to file a form and say why: resignation, retirement, termination, whatever it is. And we also have to indicate that the officer was under investigation for either a criminal or misconduct allegation within the previous 18 months. Because many times officer will resign in lieu of termination, and then we'll try to get a job somewhere else. So having that form and the requirement that that be filled out and turned into the Standards Division is a very important step. Because if that officer now applies to another agency, then during a background investigation, hopefully that information will be brought to bear and a proper hiring decision can be made. So it's not a foolproof system, but it's a good system. Other states don't have that. And as I mentioned, we have a lot of lateral transfers, out-of-state transfers into North Carolina. So some states have good systems, some states don't. It's difficult for a background investigator to navigate 49 other systems and try to figure out how to get to the information we know how to get to in North Carolina. A national decertification system would be helpful in those circumstances. And I know by executive order, recently the president has recommended that take place, and the Department of Justice is looking into it. But where we have a more robust system for officers who have been determined to be inappropriate for the profession, be that in-state or out-of-state, would be very helpful as we make hopefully the best hiring decision we can to put the right people in the right agency with the right background and culture.
So it might be useful to look at the recent legislation out of Colorado, which very effectively sought to bring some accountability to law enforcement misconduct. And that is by making certain violations of use of force or the failure to intervene or to report, making them a class 3 misdemeanor or something, so that it sort of takes it out of the quasi-voluntary negotiating employment posture and make those kinds of misconduct actual criminal offenses that can be tracked independently of a particular agency's policies. And I think that may in fact be something that points the way to other agencies and states. And I think something we ought to, as a task force, look at very carefully.
Great. Yes. So data, and I just want to point out, I'm going to move on to another policy area. But when we think about data, there's data in terms of what police officers are doing, and then they're in terms of interacting with citizens and improving that. And then there's also data collection around the police officers themselves and the conduct and files and things like that. Other just sub issues to think about with data is, I mean, do you require it? Do you incentivize the reporting of the data? Is it required? If it's required, what would be the impact of not having it? And then who's charged with studying it, right? And who's charged with studying it and translating that data? But if we move on to another policy area about crisis management, and someone in the chat mentioned crisis intervention, and I want to think about how that relates to investing in communities and and the like. So we want to talk about crisis intervention.
This is Tally Wells. I think crisis intervention training and it really not only is a great training in itself, but I think it has a lot to offer the larger conversation that we're having of really thinking through what's happening in a particular situation. And so crisis intervention training is particularly focused on mental health, but some other states have also added intellectual and developmental disabilities, particularly folks with autism and other disabilities. And then when there's an intersection with race, there's a whole nother factor that sometimes plays in depending on the situation. And I think the more that the training is about, is this person in crisis, and are we arresting this person because they have a mental illness or because they have a disability, or is it really a crime? And then how to gauge that, and then what to do about it, which is the really challenging thing, I think, for a lot of law enforcement in those critical situations. And so obviously having crisis services tied into crisis intervention training makes a lot of sense. But I think, and because there has been a lot of movement on that in the last 10 to 15 years, I think there's also some just lessons learned that we can have for this entire conversation.
And to just piggyback off that, right? Oh, excuse me, go ahead.
After you, sir, go ahead.
And to just piggyback off that, right, real quick, every officer, law enforcement officer in the state of North Carolina should be crisis intervention trained, because these are the type of, it's in this population in which some of the individual calls they respond to that they have to serve. But not only that, crisis intervention trained individuals such as particular social workers that some states are using should be part of this essential team, just as EMS respond and the fire department respond, so we can kind of alleviate some of the issues that we're having with individuals who are going through a crisis and end up being brutalized. And so just to speak to those 2 points, every officer in the state of North Carolina should be crisis intervention trained, as well as we should look into placing social workers who are crisis interventionally trained on a broad scale, being part of this essential team that come out when someone is having a crisis or just a 911 call.
I would agree that all officers statewide should be trained in CIT. One of the hurdles to that is that CIT International, which is a private group that put all this together 15 years ago, give or take, finds it is most effective to train an officer after he or she has 2 years of service. We don't necessarily agree with that, because these are very good skills that an officer should have when he or she starts employment. So we are doing some of that before that 2-year time frame. There's some other hurdles to that as well. The first is there's not enough training sessions available. So we need more organizations to put CIT training out there for the many officers that are eligible and should be taking it. And probably one of the biggest hurdles is the key to this intervention is that there's an alternative. So that when an officer determines that this is based on some mental health episode or crisis, and it's not criminal, but someone needs some help, or maybe it is criminal and that's not the best solution, then there needs to be an alternative and a treatment facility to get that person connected to. And in some of our rural counties, they just don't exist to the extent they need to. So absent an answer for that, officers have very few choices. And sometimes when there's a crime committed, that becomes bringing someone to the magistrate. And I've heard that the number one facility for mental health treatment across the country is the jail and prison system. And it shouldn't be that. So where other systems of government or of social services aren't effective, the result of that is it falls at the feet of the police. And law enforcement shouldn't be the first responders to a mental health crisis for so many reasons that we could talk about for hours. But where we do and where we intersect with that, we need alternatives, and we need systems in place where officers can be part of the solution, getting someone to more meaningful treatment. So in response to this, about 2 years ago, the International Association of Chiefs of Police started their One Mind campaign. And that was a program designed to encourage law enforcement agencies, not only nationwide, but worldwide, to do several things. The first was train their officers in CIT. The second was to have a policy and a thought out policy about how they will deal with persons in mental health crisis. The third was to train non-police forward-facing civilian employees in at least mental health first aid or some related program. And the fourth, and I think this is probably one of the more critical parts, is to establish a relationship with a behavioral health services organization in your community. So there is that alternative, there is that way to get someone in need connected with a service. So there is a lot going around that, and I think maybe this task force can further some of those initiatives and further some of the service provision so that it reduces the need for police officers to intervene.
Great. There are a number of other ideas. I'm going to turn it back over to Justice Earls. There are a number of other ideas that are captured in the chat, and my understanding is that the staff has captured that, and you will all have the benefit of looking at all of the wonderful ideas that you came up with.
Well, first of all, I so hate to stop this discussion. It's been such a rich and I've just been taking tons and tons of notes. So I want to thank our professors, Professor Smith and Professor Chavis. Thank you so much for the amazing presentation and leading us in this discussion. I'm just incredibly grateful for your work and for your willingness to spend your time with us this morning, and just hugely grateful to you. Yeah, we're all clapping virtually. So we're gonna vote. We are gonna do a very low-tech version of voting. So you all saw the minutes earlier. We were ready to vote on the minutes. We'd like to approve the minutes of the last meeting. So if all of you would unmute yourselves for just a moment so that I can call for a vote on the minutes, and we'll see if this very elementary way of voting will work for us. So I see that most of those little red microphones are gone. Okay, so I'm going to ask all of the task force members who are in favor of approving the minutes of our last task force meeting, please say aye.
Aye.
Aye. Okay, anyone opposed to the minutes? Wonderful, they've passed unanimously, and we have voted successfully, so that's a great achievement. We are now going to turn to a discussion of some initial policy recommendations, and for that, I'm going to hand this over to the expertise of our NCCJ facilitators and let you move forward with this part of the meeting.
Hey, Ben. Greetings, everyone. Greetings, Task Force. I'm Karen Dyer, working with NCCJ, and have enjoyed the conversations and the information thus far. As Justice Earls said right now, and also what she mentioned at the last meeting, is that this group is really about action. This group is really about moving forward with recommendations. And as I recall from her last meeting, she said that the recommendations, we don't have to wait until the very end, that there are recommendations that we can actually discuss and talk about as we move forward. So that is, that's what we're going to do in this time period. But what I wanted to talk about a little bit before we start talking specifically about the 3 recommendations that you've been asked to consider is I want to talk about how we are going to move forward with this group as you coalesce more as a task force group, but also as a decision-making group as we move forward there. So one of the things that we've talked about is, is how do we go about doing that work? And what we want to talk about is this whole idea of consensus. And so Michael, if you move the slide to the definition as we talk about consensus. Because ultimately what we want is as we're talking, we want to talk about some mutually accepted decisions, some mutually accepted solutions. And so as we've talked about so many of the things that we've talked about thus far, that's been the thing that we've discussed. Michael, can you move to the next slide, please? All right, so I want to talk about the criteria that we're going to use about consensus making. And so as you see here is that consensus making means that every participant agrees that they really have had sufficient opportunity to influence the decision, so that you've had a chance to talk, you've had a chance to express your concerns, you've had a chance to express your advocacy, or if you have some other concerns, you would have that chance to do that. But that's what's important for consensus. It's important that everyone agree, all members agree to support the decision, though it may not be your first choice, though it may not be the one thing that is just really floating your boat and really, pushing this forward for you, but that you truly can support this decision. That's what consensus, that's a criteria for consensus. And finally, it is that everyone is committed to the decision, even if it, even if it weren't your first choice, but that you are supportive of the decision to the point that when you go out of this, get off of Zoom and you go back to working with your constituents, you can support that decision. So this is not a case where, we leave the meeting and you go, they said, or it's what they came up with. No, it's something that, that you really will support, again, even though it may not be your first decision. So what about when there isn't consensus, or you are having difficulty supporting something that has been said? By all means, you need to explain your reasoning. You can say that, I can't support this, and you explain your reasoning why you can't support it, but also is that you provide an alternative solution. So it's not just enough to say, I don't agree, or this isn't right, or something like that. Yes, you can say that, and you can say why you say it, but also the expectation is that you're going to offer something that is, that would be an alternative. So moving on to the three recommendations that have been offered to you. They were offered to you the last time you received a lot of data and a lot of background. They were around the duty to intervene, the prohibition of the neck hold, and then the North Carolina Supreme Court rule assessing the ability to pay prior to laying fines and fees. So those were the three that were proposed the last time, the three recommendations. And now what we want to do is we want to spend just a little bit of time asking, is there anything that would actually prevent you from supporting any of these three recommendations? And if they are, what are they? And what alternatives would you have? And in addition, are there in these three recommendations, are there things that you really feel like you can get behind? So just opening it up to discussions. Again, I would say just unmute yourself and you can just go ahead and speak. But again, the two questions that I've proposed as we're trying to get to consensus, is there anything that would prevent you from supporting any three of these? And then finally, and additionally, anything that you really stand behind or really, really support?
I don't see any obstacle to a consensus. I do have a question on the third option involving the Supreme Court, whether or not that sort of covers the entire space, or whether or not the task force will be able to address the question of user fees more generally in the courthouse, and whether in court proceedings, whether at the district court or superior court, and whether we ought not give some consideration to the fact that justice is a public good, and we should not be assessing user fees in the same way that we assess tolls on a highway, and that should not necessarily be income dependent at all. And that the proliferation of these fees really came up in the last couple of decades as a budgetary concern. And what we know from Ferguson is that has very dramatic racial disparate impacts.
Henderson, this is Josh. And I think what we have been thinking, and Anita and the team and I, was definitely that these three initial proposals are not meant to be the final word on any of the topics, whether it's fines and fees, whether it's use of force policy or other policies that should be applicable to law enforcement. We just thought that these were three things that have gotten a lot of public discussion, a lot of widespread thought and understanding, and we wanted to show the state that we can move and that we can take action. And but any of these topics that fit into any of the working groups, they should continue to gnash on them and chew on them and come up with ways to make them stronger down the road.
And if I can just follow up on that a little bit, the first two proposals, so the duty to intervene and report, and the revising the use of force policy so that it prohibits the use of neck restraints or chokeholds, those two things are in the executive order being recommended for or being implemented for all of the police units that are in the Department of Public Safety, so Highway Patrol and others. So it seemed to us just a no-brainer that we can recommend that those be expanded beyond those two police forces. On what's being recommended as a Supreme Court rule, that came to us from a number of sources, but we included in the materials the request from the Chief Justice that so that this proposal of an ability to pay rule is being vetted, has been already vetted kind of widespread amongst different stakeholders. And the request was, what is the task force's view on that? I think, Henderson, the broader vision that you're talking about may require implementation that is beyond the power of the Supreme Court to enact in a general practice rule. And I think part of which just again reinforces the limited nature of these recommendations, but part of what we were seeking were things that could be done now. And so that's I think it in no way was intended to cut off consideration of broader changes that ultimately could make this initial step obsolete. But that's just a little background on how it came to us.
So I support all three proposals, but for example, with the duty to intervene proposal, I thought could benefit from the addition of some language to prevent retaliation or some whistleblower protection for maybe lower level officers who intervene. But what I'm hearing is there will be the opportunity to go back and flesh out and revisit some of these proposals.
Yes.
I'd like to weigh in on the first two. The duty to intervene, I think, is an obvious one. I think that fits very well with our oath of office. I don't know of a law enforcement agency or administrator that would say, absent a rule or absent an expectation from outside, that he or she doesn't have that expectation for his or her agency. The duty to report, I think, has always been there as well. It is required for accredited agencies under the Commission on Accreditation for Law Enforcement. There is an expectation to report. Of course, that is voluntary. So having that duty to report much more clear, having that duty to intervene much more clear, and in a policy for agencies, I think it would be very helpful. Over the last couple of months, many agencies across the state have done some internal analyses and realized that they're not as strong in their language as they should be, and have since updated their policies and made very clear a duty to intervene. And I think that's appropriate, and I think that's necessary. And I wish we would have had that nationwide several months ago, and maybe we would not have had the recent tragedy that we had. So I think that's easy. The ban on chokeholds and strangleholds, I think, is easy, but I have one concern. Most agencies have by policy already prohibited that and do not teach the use of strangleholds or chokeholds as a subduing technique. The Justice Academy lesson plan on subject control techniques includes training on positional asphyxia and making sure that the signs and symptoms of that during any use of force or any custodial activity is observed and known by the officer, and they make sure that they do what they can to keep people safe. While there is no prohibition for that, I think many agencies have, and I don't think that would be controversial at all. It's not a good technique. It's been banned in many other states for obvious reasons. My concern is this: use of force situations generally are reactive. So it's an officer reacting to resistance by someone else or some other circumstance. Now, I hate to say always, because it always is never. And I hate to see never, because for the same reason. So, but in general, use of force is reactive. So where it's reactive, it's dynamic, and an officer has to react to whatever he or she is facing. In these type of situations, it doesn't fit a nice, clean parameter of what will look good. It doesn't fit a textbook ABC 1, 2, 3 kind of situation. It can be very difficult. It can be very violent. It can be very hard to engage in by an officer just trying to subdue someone to keep everyone safe and carry out his or her duties. So with that, there is a technique that has been taught for years when someone is in a process of trying to be arrested, and that you hold someone down to handcuff them. And when you do that, you may have your knee on the person's back, not their neck, on their back. You may have your knee on their torso. You may be proning out over them just to keep them from fighting. My concern in this day and age of video is in the dynamics of that. If that officer slips, is not 100% accurate about a torso or a lower back, and it slides, what does that look like for the snippet of 5 or 10 seconds on video? And is that now become the focal point, where the totality of the circumstances, as I hope we know, is what's most important? So yes, I agree 100% in the ban on strangleholds and chokeholds, but I think we need to have some understanding around the dynamics of what occurs in these circumstances to make sure we are not jumping to a conclusion all the way from what is maybe a necessary, well, hopefully a necessary, reasonable, lawful use of force that just doesn't look as pretty as people would hope it would look like.
I had a question about that. I was talking to our chief about that, and our council actually discussed it. There are exceptions to when this can be used. What are some of the professional law enforcement? Give me your perspective about when it's necessary. She was saying in life or death situations, and that could be discretionary. So tell me what you think about the exceptions when it is okay to use it.
So normally what you have as far as exceptions like that is, again, because of the dynamics of a situation, the fact that it's ever changing and clearly not controlled by the police officer. That's why they're in this situation to start with. There's usually a caveat of if deadly force is otherwise authorized by law and to protect the officer, to protect a citizen or whatever, that any avenue necessary to be used by the officer, words to that effect, would be authorized. So if the officer is losing a ground fight, or if someone else is about to be injured or killed, can the officer use any item or any technique in his or her disposal to take the person into custody? And that's usually where you see that kind of an exception. And if my colleagues can weigh in on their perspective as well.
Chief, you're exactly right. As someone who trains and actually instructs on the selection and application of force, and I had this conversation with a few folks the other day as it relates to the actual word prohibiting and banning of chokeholds. When you reach to a deadly force, or when you get to a deadly force encounter, the manner in which that level of force is applied, it's very hard to try to put that into a box and close it in around the policy. Therefore, that would be what I would consider probably the one and only exception to that if we, were to recommend a complete prohibition against the use of a vascular neck restraint or a chokehold.
All right. Other.
This is Josh. I will say that the actual sample policy language does have that. It prohibits neck holds. It says that it shall not be used, but there is an exception unless necessary to protect the life of the officer. So I think what we're recommending to law enforcement is consistent with what we've heard today, that there really, this is not something to be done as a matter of restraint, but if the officer's life is in danger, then they have to do whatever they need to do to protect themselves.
Okay. All right, well, I'm going to move forward with calling for consensus. And just let me give you a couple of things just to know why I'm doing and why I'm saying this, is that I'm not asking, is everybody in favor? I'm asking, is there anyone that has any objections to us adopting these three? Hearing that as we've heard from other comments that have come, we've heard from Mr. Stein that language is actually in there. We've heard from Justice Earls that these three can be, we can go back to them and add more things as we go forward. So I'm asking, are there any objections? And I'm going to ask this 3 times, not to be annoying, but as part of the process for consensus.
Karen, this is Josh again. I have one more comment or thought on the fines and fees. And I thought maybe it'd be good to give everyone another, before we get to what you're asked, which I think is the right question, is to just make sure other people don't have questions or follow-up thoughts on any of the 3, if that's okay. And really, my comment on fines and fees is really building off of what Henderson said earlier, that this is just kind of one piece of this pie. And a lot of times we just say fines and fees and we don't really divide out what they are about. I mean, the fines are punitive. This is a punishment for doing something wrong. And the fees are a fiscal solution that the state has come up with to pay for our justice system. And I think we need to understand that they're a little bit different. And I think I certainly believe that people's ability to pay, their indigency, must be taken into account when assessing fines and fees. So I'm supportive of the policy. But one issue is what's the alternative? And I think this is something the working groups can wrestle with. If we so regularly go to fines as a punishment, but somebody doesn't have an ability to pay, what are alternatives to alternative sanctions, whether maybe it's community service or whatever, and then how do we ensure that that's whatever those alternatives are, that they're available to everybody, irrespective of their ability to pay, whether they're low income or middle class, that if it's an appropriate punishment, it could be available to all. And so those are just some thoughts I had as we think conceptually about fines and fees, and that working group wrestles with these things.
Are we voting to adopt this, what looks like an AOC form, or to use this as a jumping off point for task or the committee discussion?
I think what we're voting on is the principle that we urge the Supreme Court to adopt a policy on this. And the other attachments, the language and the form, are some which they are considering right now. But I don't think we are getting into the very prescriptive level of, is the form organized in exactly the correct way? Anita, do you agree with that?
I think that's right. The form was to give you a fuller context and some sense of how it might be implemented. I'm sure that the Chief, the court, AOC would all welcome if there are suggestions about ways to improve it or concerns about the form. I'm sure they would welcome that feedback. But we weren't trying to prescribe what that form or even the language of the rule. Quite frankly, we're not trying to prescribe the language of the general practice rule. We are just saying, as a task force, we endorse. We recommend that the Supreme Court consider adopting such a rule.
Yeah, it looks to me like it really just goes through and makes the judge go through the process of delineating where he would like or she would like to use their discretion in terms of costs and fees. And it's a complicated area. And as you know, Professor Markham's got lots of charts and graphs and all this stuff on it. So it's very complicated. I think a lot of my colleagues, you know, spend a lot of time trying to figure out what they can do, and you're faced with it. You know, you got to make a decision within a minute or two as to what you're going to do with this person that's in front of you. And I think something that puts in this cognitive stop, I guess you would say, that to have you go through this mental process, have a judicial officer go through the mental process is a good thing. So if this is compliant with all of the statutory restrictions on what we can and cannot do, I think it's a good thing. And then we can go back and talk about it a little more, perhaps.
So I'll continue. Thank you. And thank you both. I will continue with, are there any objections?
So this is Mike. Could I ask, I don't understand exactly what we're doing here. We're making proposals, which to me typically would come at the end of the process. And we've already seen in the discussion that there are complications to at least two of the items that need to be discussed, might need to be discussed further. Now what we're saying is that we can do that in the subgroups, in the committees. But my question is, if we do something today and then go back to our committees and find that we need to make changes, come back and make changes, is that really the best course for the committee? Does it not make more sense to vet it through the committees first and then come back with a fully developed proposal that meets? The other thing is the governor's order talks about evidence-based or evidence-informed proposals, and we're not providing evidence, whatever evidence means in this case. We're not providing any evidence. We're just saying we think these are good things. And I don't know if that makes sense or not, but that's just my thought on it.
Well, I think that, and I will yield to Justice Earls, that the idea here was to really get consensus about moving forward with these three recommendations. And you're exactly right. I mean, we've been discussing how more data, more information as the task force continue to work can continue to inform these. But at least you would have, I think the suggestion that we adopt these recommendations is that you really do have, you know, you have some movement. We're moving forward. We're not just waiting till the end for everything, because there are going to be lots of more recommendations that are going to come up, and they may inform these where you may go back to it or not. But Justice Earls?
So when I suggested that these are, or when we've been trying to be clear that these are not total solutions, that doesn't mean to suggest that these aren't policy recommendations that other stakeholders have been working on for a long time, and that there is evidence behind. And that's why in the document itself, we gave you links to some articles, to some sources of data about why these are good initial steps to take. So I do believe that each one of these three proposals is a data-based, the data being there is evidence that these will ameliorate some of the racial disparities, because remember, that is our mission. And our task is to address the racial disparities in the criminal justice system. I think we don't have the time and the need to completely reinvent the wheel and to tread over ground that other entities in the state, I mean, I don't even have to go to national, but what other entities in the state have thoroughly reviewed and researched and considered at good steps. So, and I think another criterion was these are things that can be done now. So there's a reason, in other words, there's a reason to get, and I'll just speak to the third one, I think there's a reason to get the North Carolina Supreme Court moving now on considering the ability to pay rule, even if ultimately our recommendation is that the legislature should change the penalties or change the fines and fees structure. You know, there may be legislative proposals, but right now this is something that the North Carolina Supreme Court can do without legislative action. So I think there are good reasons to make these recommendations now in a way to help the work groups get a jump start. They don't have to plow over ground that's already been pretty well reviewed by a lot of stakeholders already.
And Mike, this is Josh. I'll just add, in addition to there being evidence for these in the materials that we emailed out, I do recognize that we're moving quickly, but I think these are well understood policies. And when I said the work groups can continue to work on use of force or fines and fees, it's not that they would change these recommendations, they would add to them down the road. And to the extent we do all agree that these ban on chokeholds is good, most law enforcement agencies in North Carolina already do that, not all of them. And so if we can get this universally accepted and we agree that this is a good idea today in July, rather than waiting for December, perhaps somebody's life gets saved because of a change in law enforcement policy. So I do think there is some urgency for us to move forward when we do agree something's a good idea.
Yeah, this is Jim Woodall real quickly. I think all three of these are things that we should make as recommendations. Perhaps down the road, some of these will evolve into legislation, but I think it's real important that we take definitive steps right now, and this is a first step. And it's real difficult for me to see how any of these are objectionable.
All right, and then
let me just mention what, since my colleagues and I are the ones that are going to be signing this, if it comes to pass, I just want to make it clear that the presiding judge does not have to check any of these boxes on recommendation 3 on that form. So there's nothing that infringes upon judicial discretion. I just wanted to, is my understanding. The judge doesn't have to use the form at all, but it's something that will be there at his or her, can be employed at his or her discretion and on motion of either side. That's my understanding. Is that correct?
That's my understanding also.
Thank you.
all right, I've got the one last time to say, are there any objections to these three? Well, then it sounds as if we have consensus. But what we will need to do is, for record keeping purposes, and because it needs to be, it has been ordered by the executive order, is that we will need to call for a vote. But I do want to say that, you know, these are not mutually exclusive. It's important that we have the conversations around and try to come to consensus. And then, you know, as we vote, the vote comes out as it does. But again, as facilitators, we are always going to try to spend time, as you just experienced, trying to come to consensus. So Justice Earle, I want to turn it over to you for the vote.
I think we can vote the same way we did last time. So if everyone would please unmute yourselves. Give you a minute to do that. So then all those in favor of issuing the first 3 recommendations as provided to you, please say aye.
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 Any opposed, say no. Okay, the ayes have it. Thank you.
So I'm now going to turn this over to my colleague, Michael. Michael, come off of
Thank you,
mute.
Karen. Appreciate it. Thank you so much. I just want to say, let me get my slides working. I just want to say how grateful I am to be with you all today, and how awed and humbled I am at your expertise and who you are as people. We've all been called together to do something I feel is, and I think that you all too feel is bigger than us. Mr. Clemens spoke earlier about the need to not just think about what is in our heads, but what is in our hearts. And, you know, as we think about what it means to develop and help implement solutions that eliminate disparate outcomes, I think it's really important for us to consider what that means, who we are outside of just the expertise we're bringing to the table. Because you all have been called here for the wonderful expertise that you bring, but that we are also considering the fact that we are all people who are impacted by these policies and these practices. I'm a North Carolina, I've grown up in North Carolina my whole life. I've been here my whole life, and have had family who've been impacted by the criminal justice system in a number of ways. And Black bodies, brown bodies, and white bodies all need to be protected by the system. And before we move on into thinking about, so what does this mean for us? Because we only have a few minutes left. And so a lot of the work that we're going to be doing around thinking about what does it mean for us to vision this future, because it's not just that we're thinking about, okay, what kind of recommendations need to be made, but how do we actually go about implementing these things and making sure that they go past the recommendation phase to implementation phase. I'd like to share a quick quote by Ta-Nehisi Coates, which says, but all our phrasing, race relations, racial chasm, racial justice, racial profiling, white privilege, even white supremacy, serves to obscure that racism is a visceral experience that it dislodges brains, blocks airways, rips muscle, extracts organs, cracks bones, breaks teeth. You must always remember that the sociology, the history, the economics, the graphs, the charts, the regressions all land with great violence upon the body. And I think that means the body of the people who are feeling that, but also the people who are asked to provide protection and security. And so everyone matters in this conversation. All our communities matter. And so as we move into thinking through what these recommendations are for now and the future, right? We have some actionable steps that we've taken already to say these are things that we can do right now to help save lives, right? The reason I share that quote is to say that this is about people. And I know we know that, but I think it's important for us to center that in the conversation. And so as you consider, we transition into working group, here are some things that I think are important for us to think about. And we will be working with you all to frame and to hold space together as you work together to come up with the next steps towards an ideal future for criminal justice. What are the takeaways from the presentation this morning that you've had that informs your understanding of the problem of racial inequities in the criminal justice system? A lot of us have a wealth of knowledge to bring to the table, but is there something that you learned, some perspective that you gained that informs your own perspective, and how is that carrying through to tomorrow for you? And you're thinking about the work that we're going to be taking up in the next few months. Now, based on what we know, as I said, we hold a lot of knowledge, but we hopefully have learned some things today. And part of this is saying, okay, we have a system that exist as it is, and being the case that it's going to take a long time, generational change, to see some of the recommendations, some of the changes that we want to see made actually impact, having the impact that we want to see. I think it's important for us to consider for ourselves as individuals, what is the ideal future state for criminal justice in our state of North Carolina? We have a lot of recommendations. I mean, the chat box has been flooded with amazing ideas. How does this translate into what the future state for my child who's 3 years old? I mentioned that because she might make some noise here, you may hear in the background. For my child, when she's my age, what can we say we did today and in the 6 months that will, and in the future, carrying on past December, that will help create an ideal future state for criminal justice in our state? And so these ideas, we're gonna send these to you because I would like you all to think about these things as you go into your small groups for your next meetings. These three, but also while many of us are here because of our profession and what our pedigrees are, there's also parts of our identity that need to be acknowledged that we also are bringing into this task force that I think are important for us to consider as we think about what it means to specifically eliminate the disparate outcomes for communities of color. Right? So this question here, how might your personal and professional perspective inform? Right? We have our professional perspective, but how might also your personal perspective inform your ability to help the task force accomplish its mission? And lastly, what might you need as an individual to make sure that you feel comfortable sharing your perspective, offering your expertise and recommendations, that those ideas are honored, respected, and valued by folks in your groups and in a large group? We have a couple of minutes left. And so I want to open it up to folks before we close out to consider, what have you learned? Go back to that slide. What have you learned today that you feel will inform how you move and show up in your small groups? And what are some things that you might need in order to feel that you are prepared to take on the tasks that we've been set to take on? And feel free to just unmute yourselves and share openly over the next couple of minutes.
Well, this is Henderson Hill. I feel good that I've had the chance to sit around the table with a sheriff from Richmond County and a commissioner from Transylvania County. And it's the first time in my life I've had that privilege. And, I think we've had, even this quickly, a sharing of perspectives that's been healthy. And that I think the citizens of North Carolina need to know is taking place on these important issues. And so that's the first thing. I just feel grateful about the morning. I do think as we work on the small groups and exchange with each other, I'm interested in finding out about the special experiences of my colleagues. I feel, in my 39th year at the bar, I've had a lot of experiences myself that have shaped my views on this. And I look forward to sharing that and thinking as we do this exchange, we come out stronger as a task force and we're able to deliver on the government's challenge.
This is Sheriff Clemens. I agree with the comments made by Henderson. Also, what I'm looking at is that this great group too can also, not only what we're doing for the state of North Carolina and bringing everyone together, but also as a professional, it would help me with my agency, making sure that we're hearing the voices of the community and then those that don't live into the community to help us with best practices and ways in which we can improve our sheriff's office and make us more professional and take those ideas to the streets and to the community and how we can work together as one voice, one beat, and one motion. So I'm very thankful of being given an opportunity to share the platform with so many great professionals on this list of faces that I see. And I look forward to the great work that can only help us become better in the state of North Carolina.
On that note, this is Callie Wells. I'll just say very quickly that I think we need to get the word out about the public comment. I'm getting it out to the disability community, so we'll definitely have disability comment, but if we need to have more than that.
Well, thank you so much. Mr. Robinson, you really have concluded today well, and I want to thank all of our presenters and our facilitators. Enormously grateful to you. We are out of time. Let me turn it over to my co-chair, Attorney General Stein. Do you want some closing words to leave us with?
Sure, just words of thanks. I'm very excited. I mean, we took action on 3 very important criminal justice reforms today, and I think we should be proud of that. And we all know that these are just first steps, and that the working groups are going to do a lot of hard work working on a comprehensive review of our criminal justice system so that it is fair, that it is better, and that's what we all want. The working group chairs, staff, our co-leads will be following up with each person about their working group and when that will next be meeting so that we can make sure that those sessions are absolutely as effective as possible. And Tally, thanks for putting in a plug about the public hearing that we're going to be having. And we'll continue to get the word out about that so that we can hear not only from ourselves, but from North Carolinians who also have a lot of good ideas. Thanks, everybody.
So we welcome further feedback on the last 2 questions that were raised, particularly what do you need from us to be effective on this commission? I am so deeply appreciative to all of you. I know what an incredible wealth of talent, experience, wisdom, knowledge that we have gathered on this task force, and it's an honor for me to be working with you. Look forward to seeing you all next Tuesday morning at our public hearing. And thank you so much for your time. Well, that concludes our meeting.
Thank you.
Have a
Thank
good
you
week.
all.
Bye-bye, everybody.